Good morning, everyone, and welcome into KVEC's Principal Support Network. And today's topic is going to be what principals need to know about discipline. We would like to welcome each and every one of you here to our cadre. We're joined by our behavior specialist, Doug Smith, and of course, Dr. Dion Bates is on here with us today. And so I think it's some useful information that we can use to continue to understand the complexities of working with students with disabilities, and when discipline is a factor, how difficult that can be, and how important it is that we are aware of some things. And we once again appreciate you being here with Kentucky Valley Educational Cooperative and our Principal Support Network. So the agenda today is going to look at idea protections. We're going to dive into manifestation determination, short-term removals, FAPE obligations, behavior intervention plans, functional behavioral assessments, the 45 school day interim alternative educational setting removal, some proactive strategies, what it means to communicate and collaborate, and some ongoing professional development as we support uh, not only our teachers but our students in terms of providing the best possible education for all students. Um, so the bulk of what the information that we're sharing today comes from this resource. Um, it comes from a Principal's Guide to Special Education. It's written by David Bateman, who is one of my favorite authors. It's just really, really a simple um, approach, and we're going to really kind of look at the top 10 things that principals are supposed to know or need to know, according to David Bateman and his um, colleague Fred Bateman, that wrote this book with him. Now, he has several of these books that we have read over the years, and they're all excellent. He's an excellent speaker. So we wanted to just share this with you. So the first thing that we were going to talk about, and I just wanted you to consider a section, is I want you to think about what the the first thing I want to do is, and this thing works better if we have a conversation. We'd love to hear from you guys who are out there in the trenches doing it. IDEA is something that it's a complex law, the Individuals with Disabilities Education Act, and within that uh, act, there's really several cornerstone pieces, if you will. Uh, there's several uh, tenets. There's like six big ones, and one of those is the protections that students with disabilities have. It's really their rights, and so right now, what I'd like for you to do is either unmute and tell us what you know about the discipline of students with disabilities, or put just one or two things in the chat so that we can get this conversation rolling. Nathan Arnett says, as far as discipline goes, removal from placement has to be considered when applying consequences. I think that's a great point, and we already have down here on our screen that a common misconception is that students with disabilities cannot be disciplined, and that's absolutely not true. We have to look deeper beyond the code of conduct and the things that have gone on. We have to look at the disability, and so I think that's very much true what you say, or you're saying there, Nathan. I appreciate the comment. Well, as we think about this, let's drop back for just a second and let's talk about, okay, Steve Cole from South McGoffin Elementary. I always consider the limit of days you can suspend a student with an IP. That is certainly something to be tremendously aware of, because once you hit a certain number of days, and it's the 11th day of removal, once you hit that 11th day of removal, um, that is considered a change of placement. And there are things that you, as the chairperson in your school, have to do in order to take care of that situation, so to speak. And so, uh, that is very much a good piece of information to know, and certainly if you're leading your ARC teams, very very important. Now, let's drop back for just a second as you can continue to consider this topic. Um, when when IDEA was born way back in 1975, and it's coming, it has a 50th anniversary this year, and we were talking about it in the office the other day, and I got kind of tickled at some of our colleagues. I think it was Dr. Bates that made mention that we're all a little bit older than this, probably minus Chastity Kraft, who's our uh, literacy consultant, but everybody on our staff is a little bit older than this. So we've been around the entire time for this law, Public Law 94-142, the Education of All Handicapped Children Act came about in 1975, and when it did, uh, it was really a lot of the information that came out around that was we need to make sure that first of all we're going to give you money in those states to work with these children that have disabilities, but it was in 1975, we were coming out of the civil rights era, and it was all about inclusion. It was all about making sure that we were providing access. And then it started to talk. The law started to evolve a little bit, the cornerstone documents the IEP, and that's how we provide services. And then as the progression continued, it was all okay. Now districts, in order to be compliant, you have to uh, be procedurally compliant. You got to get the right people to the meetings. You got to make sure that the IEP has all the components, that the timelines are taken care of, that you have invited people properly. Those are all procedural uh, situations. And those procedures, sometimes if you, as a district, if you do not take care of those procedures and it results in a student not receiving services, then certainly you could be liable for that and get into tons of trouble with litigation and those types of things. And then, around 1982, there was a major case called the Raleigh uh, versus the Hendrickson Hudson School District up in upstate New York. And the Raleigh case really reinforced the fact that you had to be procedurally sound. And it also said that, you have to provide at least a basic floor of opportunity for advancement and to receive some uh, a bit of a calculated IEP in terms of what the student's going to benefit. And for 35 years that held, but as as the history of idea continued to progress and the involvement of the law continued, the appellate courts, we have 11 of those in the nation, plus the District of Columbia, which would be a 12th district. And each of those districts then, because the Supreme Court stopped short of saying how much benefit a student should get from an IEP, we started to see a splintering at that level, and that splintering of the decision making around how much benefit should an IEP convey to a student with a disability then became, well, we just have to do more than the minimum, just a little bit more than the minimum, or we have to do the minimum, or we have to do a reasonable calculation that is based on the student's unique potential. And I think the sixth district in which we reside in Kentucky uh, pushed that bar further than anyone during those 35 years. And it culminated in a case referred to as the Deal case in 2004, where the language that came from that was that every student uh, that has a disability has the right to a reasonably calculated IEP. And that puts a lot of pressure on ARC chairpersons to make sure that things like goals are written and goals are measurable, and we have progress monitoring going on. And so we started to see that emerge around 2004. Kentucky continued to be at the forefront of that. And as we moved through, in 2017, there were still some of those appellate courts that I spoke of that were lagging behind. And that brought the Andrew case. And the Andrew case just kind of reconfirmed Riley in that, number one, you have to be procedurally correct. Number two, you have to provide a benefit from the IP. And part of that procedurally correct is making sure that the protections for students with disabilities are there and in place. And it comes in the form of procedural safeguards. And those procedural safeguards are those protections that we're talking about, that gives the parent the right to be involved, and ensures that we have child find activities going on in our district, that we are conducting evaluations appropriately, and that we're using those evaluations to make sure that we determine the student's eligibility correctly, and that we're not over identifying. And then from that, we have to make sure that we're applying discipline the correct way, because discipline is a very deep subject. So we'll move on here. And now that we have some perspective around what IDEA means and and where it is and where we're currently working, and there was a huge case. In case you guys haven't heard, there's a case out of Alabama that I spoke about last month that everyone needs to be aware of. This young man was going to school. He was a non-reader. He was dyslexic, and they determined that finally, by the time that he was in the 11th grade, with an appropriate evaluation, they'd had evaluations, and he was in special education, and he was receiving pretty much accommodations only at the high school level, and nothing was being done to address his reading difficulties in terms of specially designed instruction being provided. It even got a little deeper. They were allowing him to use ChatGPT to write papers, and then they were allowing him to use Grammarly to check and correct his papers. And he graduated with a 3.4 GPA. And this just happened in February 25. This came before the courts down in the Sixth Circuit. And I think that typically the Sixth Circuit's housed there in Cincinnati. And the findings were that this student, he had a 3.4 GPA, he graduated, and then the parents, after realizing that, he had dyslexia the entire time, and they had not addressed through specially designed instruction his reading difficulties, and had only provided him accommodations, the school district was found to be in violation of FAPE. They had to provide 888 hours of compensatory education to this young man in the form of reading instruction. Very costly, and of course you don't. And in case you don't know, that compensatory education cannot be provided during the school day. It has to be after the school hours and on the weekends. And it was a very costly proposition. And it's one that opened our eyes here, particularly in Kentucky, where we put a lot of emphasis on the test. And the test is important. I'm not saying the test is not important, but we also have a responsibility to provide FAPE. And when we do allow that to go by the wayside in the form of just accommodating kids, we run the risk of getting into the same kind of trouble that they got down there in Alabama. So I just wanted to throw that in there as well, to make sure that everybody knows what everybody knows here for the good of the group. So the core of IDEA discipline is that students are subject to the same code of conduct. Okay. A few years ago, we had a district that had written into their policy, in their site-based policy at a particular high school, that any kid that got in a fight in their school was moved to the alternative school, and without any kind of look at whether or not that student was a student with disability. That's the kind of thing we're talking about. We're subject to the same code of conduct, but we have some protections under that discipline, under the IDEA law. So has the student been suspended less than 10 days? If they have been suspended less than 10 days, then you can continue to apply the code of conduct. If they're suspended more than 10 days and hit that 11th day of removal, then there's some things we have to do, and we have to have a manifestation determination. Is that a change in educational setting? Yes. When it hits the 11th day, it is a change in educational setting. Now, the thing that I want to emphasize, and I want to say it several times as we move through this information, is that we need to make sure that FAPE is continued to be provided no matter how much we restrict the environment. And for every step down, or for every uh, more degree of restriction that we provide for that student, it should be that our documentation is written in a way that it's meant to bring progress. It's not a punitive thing that when we move that student, we're moving them into an environment where they can be successful. And everything we put in that IEP based on that FBA and that behavioral intervention plan needs to result in a discussion that says this is where the kid can make progress on the goals. This is where the kid can make progress in the general curriculum, because the idea is very clear that the students should be meeting, with the use of supplementary aids and services, they should be meeting the standards. And so when a student is suspended for more than 10 days, when it hits that 11th day, whatever plan you have for them, whatever way you're going to restrict that environment as an ARC, you also have to keep in mind that your documentation needs to be written in a way that is with fidelity, that it's going to continue to provide that student an approximation of what they have been receiving prior to. So if they're in the high school there in McGoffin County, and then they go on into an alternative educational setting, we have to continue to provide general education, special education, and that's a non-negotiable in terms of the things that we can do in terms of dealing with students that have outstanding discipline. So a change in education. And so the change is coming if the student is removed more than 10 days. If the removal surpasses 10 days in a school year, the student repeatedly exhibits similar disruptive behaviors, or there's specific factors including frequency, length, and nature of the removals that come into play. Now, what are they talking about here? So, if they have a series of removals that are very similar, then that is a pattern that we see, and that is certainly one where we would have to count the days cumulatively. So if you have two days suspended, and then you suspend for 5 days, it doesn't start over just because you suspended for 2 days and they went to school for a while. You have to think about what is the similarities between the two offenses, and how does that relate to the disability. And so very, very very clear here in the law that a series of removals, and it gets a little deep in terms of when you're working through that manifestation determination as to how you apply the law. And the bar is very high in terms of what they consider serious offenses. So we're going to talk about the 45-day removal here in just a few minutes, but when we're talking about just a simple beyond the 10 days, we have to look at those 10 days. We have to look at what occurred during those 10 days, how similar those offenses are, and whether or not, a student's code of conduct violation is really a result of the student's disability. And so we have to look at how frequent it happened, how long this has been going on, and what are the nature of the removals. That all comes into play as we consider what we're going to do with this student as we hit that 11th day of removal. So what do we know about the change in educational setting? The IEP must be followed no matter what decision we make. A manifestation determination is vital to discern if the infraction is a byproduct of the disability or the school's failure to implement the what. Who wants to raise their hand and answer that question? What do we have to implement? It says the manifestation determination is vital to discern if the infraction is a byproduct of the disability or the school's failure to implement the what. Mr. Helton says the IEP. That's exactly right. If we fail to implement, if we fail to work with that student in terms of the IEP, if that student has behavior goals and those behavior goals are not working seemingly, we have to go back to the table and adjust. And what gets ARCs in trouble in this regard, and I've said this many times in ARC chairperson training, what gets ARC folk in trouble in terms of how they apply this is when you as the administrator in your school, when you start to see a student with a disability on your radar, and we don't do our due diligence and have a conversation with our special ed teachers about what's going on with that student and what have we done in the interim. We don't want to wait up till we hit the 11th day and say, oh, we didn't try anything different at day 4 or day 7. So that's something we really need to think about. And that is part of that failure to implement. That can come back on us if we're not very careful in terms of how we apply discipline. And so the other thing that I wanted you to be aware of, that in Kentucky, we have a 24-hour notice of ARC that you can use. Now, all other notices of ARC should have a 7-day calendar application. Okay, so at the top of the ARC notice, it says today is January 9th. Okay, in the middle of that ARC notice, it should not be less than 7 days in the future. So it shouldn't be that meeting shouldn't be held any sooner than the 16th. No matter what the parents tell you, that's the way the form needs to be written. There always should be a 7-day gap there. Now, the parents can ask, because the second part of that regulation is that they can ask to meet sooner, and you just document it as such. But you should always give a 7-day notice unless you're dealing with an emergency situation. The students violated the code of conduct. You have the right, and Teresa Combs was an advocate for administrators. She's tremendous when it comes to this kind of thing. And several years ago, she was able to get the 24-hour notice into regulation. So that is certainly a tool that you can use if you need to have that meeting. If you got a student and they've threatened the homecoming queen, or they've done something really horrible, and you need to have a 24-hour our meeting in 24 hours to decide what the action is going to be. You certainly have that tool in your toolbox to use. Any questions about what a manifestation is? We're going to talk about, but it's vital to look to see if the infraction is a byproduct of the disability or the school's failure to implement the IEP. The IEP must be followed no matter what decision we make in terms of placement and in terms of where we're going to provide a FAPE for a student. And we have a responsibility to document appropriately that the decisions the ARC is making is not based on we want to get him out of the school. Well, that might be the case, but you still have to do the due diligence because they have additional protection under the discipline law and under IDEA that says, hey, we've got to make sure that what we're doing is meant to bring progress, and that will keep you out of hot water, in terms of what I understand and what I've learned from Teresa Combs and Brenda Combs and folks like that talking to us about discipline. Now, if the misconduct is linked, ensure a complete implementation of the IEP and then conduct an FBA, a functional behavioral evaluation, in which you have to have permission from the parent. Now, as you start a manifestation determination and you start to look at this change in educational setting, one of the questions that's asked, and Infinite Campus is set up kind of nice because it won't allow you to go on. If you answer this question, no, I don't have an FBA, then you're supposed to stop and get an FBA and then reconvene your meeting at a later date when you have that data. And that purpose of that functional behavioral evaluation is really going to tell us, what's the function of that behavior? I mean, it's named exactly what it means. What is the function of the behavior? Typically, we've learned from Dr. Terry Scott and from Doug and listening to him talk about discipline. Behavior has two functions. You're going to get something or you're going to avoid something. Okay. So knowing that, we need to conduct a functional behavioral evaluation. We need to have good, solid rating scales. We need to have good, solid behavioral observations. And a lot of that information is anecdotal. It's qualitative in nature, and we have to be able to make sure that it's something that we can measure. So we have to turn those numbers that we get from those rating scales into some hard data that we can determine a baseline and determine a goal that we're going to work on. And that's certainly super important. And then if we find that the student, if their behavior was a byproduct of the disability, we just have to return them to the previous setting until, and while we're doing the functional behavioral assessment, you're not supposed to remove the student. Now, so that's something that is maybe a misunderstanding, but certainly we have to make sure that our decisions are sound, they're based on data, and that we are in fact applying the law correctly, because this is an area that it's highly litigated area in special education. And by the way, about 95% of all litigation in education school law comes from special education. So it's a highly litigated area. So it's important to know these things. So conversely, if the behavior is unrelated to the disability and the IEP has been fully implemented, the school can apply the disciplinary action as they would for any other student. So going back to that first question, can students with disabilities be disciplined? Yes, they can. Yes, they can. We just have to make sure that we're doing our due diligence and that we're properly applying FAPE, that we're properly applying the ideal law, and that we're making good decisions. And, it's super, super important to know that. Now, the manifestation determination review. I've got this question. What must we do when a manifestation determination is needed? Take a moment, think about it, and place your answers in the chat. What must we do when a manifestation determination is needed? When is it needed? What are our responsibilities when it is needed? And how do we go about making sure that we've followed the law with a manifestation determination review? So take a minute and don't shy away from this. We're going to learn together. I've got the chat open, so I'd like to see some answers. What must we do when a manifestation determination is needed? Just think about all the things that you would do if you are faced with this 11th day removal. Students definitely going to have an educational setting change. There's no way around it, okay? The series of removals equal 11. And now we must do a manifestation determination. And we should be always thinking manifestation determination if the student has a disability and we're removing them. Hold a meeting within 10 days. That's exactly right, Jessica. Thank you so much for that. And you can do it in less time based on that 24-hour notice, but you must hold a meeting within 10 days and what Jessica, since you put that in there, what do we have to tell parents at that time?
That got a little too much to type.
A little bit too much to type. Go ahead and tell us what.
10 days is the requirement, I think, for the meeting.
Mm-hmm.
And then it's determining whether or not the behavior was related to the disability or if there was some kind of school failure in the implementation of the IEP.
Right. And Mr. Helton put in the chat, conduct an FBA, review the data, conduct an ARC meeting. That's exactly right. And we appreciate those answers. And Jessica, you're exactly right. But we have to inform that parent, though, that the intention is that there's going to be a change of placement. That is super, super important to let them know and to document as such that this is a meeting where we're going to have to take action. And but we don't know what that is because we can't predetermine that, right? And that's why that district that I was talking about, when they were trying to do something good in terms of cutting down on the amount of violence in their school, and it was working really. But at the same time, you can't predetermine a placement. Okay, so you can't say in your policies and procedures, hey, uh, all students that get in fights are going to be placed at Breathitt County. You can't do that. That is a violation of federal law, which is IDEA, and so be very careful about that. But you're exactly right, Gary. That conduct an FBA, review the data, conduct an ARC meeting. Those are all solid. All right, so let's see here for a second. So short-term removals. Now, students with disabilities may be removed for up to 10 days. We all kind of know that now. We've kind of hammered that in. And I know you guys have been the benefactor of having Teresa Combs come and work with you. Even this past summer, we had her for a half a day up there, and she's fabulous when she does those types of things. But we also have reinforced these types of information in uh, our ARC chair meetings, in our conversations, and certainly we're always here for you. And I would recommend getting up with me, Brenda, Dion, Doug, and all of us putting our heads together when it's a tough situation. And there's lots of tough situations, but just know that short-term removals, and I think we all know that. Students with disabilities may be removed for up to 10 days without it being a change of placement. But what else matters? When you remove them, what do you have to do? That's the question. We still have to provide FAPE. We still have to make sure that they're getting their general education classes. If you have ensure that the IEP is being implemented, that's exactly right, Doug. Thank you. Certainly, that is super, super important. You may have in-school suspension, and there's a high bar that KDE looks at in terms of what it meant. If you can call that either an in-school removal or an out-of-school removal, it's going to be an out-of-school removal if you're not providing the IEP and you're not providing the general ed instruction and the specially designed instruction that the student is used to having. So that is certainly super important. So short-term removals, you're removed up to 10 days as long as a student with disabilities receives the same treatment as well. Okay, so you can't have a policy that allows you to remove students with disabilities for things to in-school suspension and not apply that same discipline measure to every other student in the school. Okay, so you can't make differences there. That's a discrimination piece, and that was one of the things that we wanted to talk about because David Bateman talks about that at length because that's something that must go on where he is from, which is Pennsylvania, quite a bit. So the fourth thing is FAPE obligations. On the 11th day of removal, what do we have to do as a local education agency? We have to make sure what? We continue to implement, continue to provide access to the general ed and implement IEP goals. And I said, yes. Can't stress that enough. Okay. And I know that school sometimes can be difficult. And little fellas can make school difficult for us. Makes it uncomfortable for everyone. It's hard to have school sometimes for students that have these types of disruptive behaviors. But we have to make sure that when we make that decision to move or restrict further, that we continue to provide the IEP goal implementation, the general ed implementation, and all the things in between that go into that. However that IEP is written, that's how it needs to be implemented, as close as you can get to it. Okay. Some people say, well, we put, go on homebound, they only get 2 hours of this and they only get 2 hours of that. You better make sure that you're providing an approximation of the minutes. Now, does it have to be minute for minute? Probably not, but we need to try to get as close as possible. All right, we'll move on to number 5. And the behavior intervention plan is something that we need to consider. If students' behavior impacts learning of themselves and others, PBIS must be considered in the form of a BIP. If a student has one, what then? What do we do with the behavior intervention plan? What are our responsibilities once a student has a behavior intervention? I want to hear from you guys. Super important to know what it is that we are trying to accomplish in the form of a BIP. If a student has one, what do we do? What is it? If the student's behavior impacts learning of themselves and others, PBIS must be considered. Now, out here in the cloud, I have a fairly new acronym. It's one that I think David Bateman and Mitchell Yale, the guys that collaborate on legal stuff, all things legal in regards to the special ed world, they come up with this. They call it KVEC, and Willie Cole says knew or should have known. What do we? What should we know, or what should we have known in regards to discipline? So in the form of a BIP, if a student has one, what then? We review and we modify it. Okay? That's what we're talking about. That leaving that trail of breadcrumbs where the administrator has been the professional in the building and has led his young special education staff in a way that we not only provide what the student needs, which is most important, but we also meet the letter of the law, and that we provide students with disabilities a fair chance to make progress. And when we know that the goals aren't working, and Jessica says it's not optional, it's part of the IEP, is the behavior supporting learning and safety of the student. That's a key piece right there. Key piece. We know that we get this kid on our radar. We get a discipline referral in our office. What do we do? Okay. Well, we do what we do in those first 10 days, right? We apply discipline just as any other kid. But we also have to remember, one, we have to continue to implement. Two, when they hit our office that second time, something in that IEP is not working on that behavior intervention plan. And this might be a kid that is SLD. This might be a kid that has a different type of disability than what doesn't mean it's all related to EBD or autism. It can be just any of our students. Once they hit our radar the second time with a discipline referral, and we know they've got a disability, or a student with a disability, then we need to be thinking about, do they have a behavior intervention plan? Are we applying PBIS? Is PBIS being applied with fidelity? And PBIS, the literature in that is very strong in terms of with all students, RTI, they should be getting PBIS. These are, these positive behavior and supports is super, 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 super important because, and I want to go ahead and say that, if you need help with that, we certainly are here to help you in terms of identifying. And I think Doug's been working on a behavior tool that shows you what specially designed instruction looks like, but also makes the point that it's peer-reviewed instruction or peer-reviewed strategies that we're using. It's tried and true strategies that have worked with other students that are like the students that we're dealing with. And so it's super, super important that we know or should have known, and what we do after we knew or should have known, then we know that the student is not making progress, and that progress check should tell us to make an instructional or a behavioral instructional change. And that's one place I would point you, and I didn't put it in the resources, probably should have, is the Center for Discipline at the University of Louisville, Dr. Terry Scott, and the work that group does. We have a consultant that comes and works with us. She's part of our directors meetings, and her name's Nina Ingram. And there's a ton of video production on that site under Dr. Terry Scott's watchful eye that shows teachers how to apply discipline measures within the classroom. And I think it's something that would be very helpful for, especially I know a lot of you are dealing with younger teachers and teachers that have less than 5 years of experience and that kind of thing. Certainly, and we all can benefit from it. And so I would point you to that anytime you had a question. Of course, Doug can help you tremendously with those types of things as well. And, you know, we just want to be on the same team, help support you guys. We know you have a hard job, but it's important that we're, when we know that something's not right with the student, that we're reviewing those plans when they have a disability, when they have a 504 plan, when they have an IEP. We need to really look hard at that.
Uh,
So, go ahead.
Mr. May, could I interject to one more
Absolutely.
about
Thanks,
behavior
Doug.
intervention plans? I think one of the things, or one of the, and this is just my thought, you guys, have a lot of folks that you have to kind of be responsible for, let's just say it that way. And I think one of the main things with a behavior intervention plan, as far as administrators, as far as principals, is make sure or try to ensure that that plan is being implemented with fidelity, it's being shared across settings, you're teaching desired behaviors, you're looking for a system of reinforcement, you're looking at what are some small steps that I can take to ensure that this student's going to be successful in my school. Now, and Denny, Mr. May was talking about PBIS, and when we're looking at PBIS, of course, PBIS are those, it looks at academic or behavior just like academics. You have your three tiers of intervention. Now, if we're doing an FBA, completing an FBA to write a behavior intervention plan, you got to look at that tiers of intervention. That is a tier 3 strategy because those are individualized plans just for that specific student. What are we going to do specifically for that student to ensure that they're successful in school? So, as administrators, you have a tasking job to try to ensure that everyone's on the same page when following, the PBIS strategies in your school and when you're developing the behavior intervention plans. And also PBIS, like I said, it's a tier 3 of behavior plans, a tier 3 strategy. Just because we went to a behavior plan doesn't mean we stop with tier 1 strategies, school-wide implementation, positive behaviors, look at our teaching matrix, look at our classroom rules and what is it, expectations, teaching those. We don't stop just because this kiddo's in tier 3 with tier 1 and tier 2 strategies. You continue to use those strategies. This is just an extra layer that we add onto this student to ensure their success at school.
And Doug, I really appreciate that because it goes back to failure to implement. If you're not ensuring that these plans are being followed and implemented with fidelity, then we're failing to implement. And so when we fail to implement, that ties our hands in terms of uh, those restrictions that we can apply even after that 11th day of removal. If it's found that we haven't applied the behavior intervention plan correctly, then certainly it's going to be a problem. And one of the things that I think you need to impress upon your staff as much as possible is we're teachers. Okay, we need to be teaching students how to act and teaching students what coping skills are available. Those are the types of things that we're talking about, not just immediately remove them, not just bring them to the principal's office, but teach them replacement behaviors. And through the use of PBIS and some of these strategies and some of this information that we have that we can share with you, that is certainly a little more doable. Still a very difficult job, and we know we don't. I don't even want to even pretend that I know what it means to be a principal, and I know that you guys have lots of pressure on you. But that's one of those things where we cannot. Once we see that kid being disruptive, or once we see them on our radar, it should perk our ears up to have that conversation on, especially that second communication with the teacher of record. Make sure that we start to look at that plan and we start to adjust things, and that leaves, like I said, a trail. Um, it leaves a documentation trail that says that we've done what we needed to do, that we've made a good faith effort to help this child, not that we're just applying discipline, punitive damage, punitive damage, punitive damage. And those types of things we know don't work. What we do know that the research tells us, and Doug can back this up, is that positive works. Positive works. We have to work on developing relationships. And the other thing that works, and one of the things I want to give Doug a shout out, he does a tremendous job on, is he has a training that is based on opportunities to respond, which is also based on some work around Anita Archer, who I truly love. You guys know that. And also, it's based on some of the work of Terry Scott at the University of Louisville. So those are super, super, super good resources for us to reach out when we're having trouble in our schools. And, getting back to, are we teaching? Are the students learning? Are we implementing with fidelity? And we can't, we're tying our hands discipline wise if we're not ensuring that those things are happening. I think that was a great point, Doug, and I appreciate all the interjecting. Anything further as we move on beyond KVEC, I want you to know, and that, you can also apply that not just to discipline, but you knew or should have known that the student's not making progress in reading, just like that young man that we mentioned earlier in Alabama who was dyslexic, was not receiving any specially designed instruction. He was just being accommodated and taught. And now, am I saying there's things wrong with accommodating? No, it needs to be a nice mix of instruction related to the goals if a student has an IEP, as well as the accommodations. So, we got everybody in co-teaching. Well, we got to figure out how to not only provide the content, get students ready to take the test, but also we have to teach them to read better. And I don't know how else to say it. People are getting sued over it. Okay. So there is a time, and the trend, we talked about the idea trend. The idea trend is to results driven accountability for ARC chairpersons. And in my opinion, the way to change the culture in your school is to transform your teachers through transformational leadership, where you take them into account and you pour into them and you teach them and you model for them, and you are the voice, a unified voice that says we're going to include everyone, and we're going to do our very best to educate, and we're going to do our very best to make sure that everybody's receiving the equitable services that they so deserve, whether it's a student in tier 2 that doesn't have a disability yet, or a student that has a disability. On both sides of that fence, that everybody's getting what they need when they need it. And that's so super important. Functional behavioral assessments. And Doug, you're very welcome to chime in here. Before creating a plan, evaluate. What's the point of an FBA? And I may have said this earlier, but let's just have a little review here. Let's see who was paying attention. What is the point of a functional behavioral assessment? What are we hoping to accomplish with a functional behavioral assessment? Find the why behind the behaviors. I like it. I like it a lot. Determine the reason or the function of the behavior. Let's determine the reason. Why is little Johnny or little Sally acting the way they are acting? Is there what happens before, what happens during, what happens after, that little ABC approximation? But then also collect data and design support. I love it. As Jessica chimes in once again, thank you. Anyone else want to chime in with this? So an FBA is, it provides the function. It determines the function of behavior. What are two universal knowns about behavior? Is that it has two functions. What are they? What are the two functions? Gain or avoid. Steve Cole says, thank you, Steve. I appreciate that. Get something or avoid. Gain or avoid. I think everybody's got that. So now if they're trying to gain something or avoid something, we have to design some replacement behaviors that are positive for those behaviors, to teach them to cope, to teach them to use other mechanisms whereby they can control their impulses. A lot of these little fellas come to us ill-equipped to be in structure. You guys know what I'm talking about. They come into kindergarten, they come into preschool, they come into Head Start, come into first grade, and they have not been used to having to sit for any length of time. You have to take those things into account. You have to get them engaged. You have to give them opportunities to be involved, and you have to make sure that you're applying strategies that are positive in nature, teaching them to cope. Give them a little time to get acclimated to the structure.
Make another comment.
Absolutely.
Doug, again, I'm sorry. I'll try not to be too long. One of the things with when we're looking at some of the steps involved in developing an FBA is first you have to define the behavior. What
Okay.
is the undesired or the behavior of concern? And when you define that behavior, it should be defined in a way that is measurable, observable, and objective. And it should be defined in a way that no doubt in my mind that is the behavior that they're talking about. So specifically defining that behavior in terms that everyone involved can understand what that behavior looks like. Then one of the things that I think it was one of the folks put in the chat was that gathering that data. I think that's the difficult part about completing or writing FBAs is gathering the data that's involved in, making sure that we are looking at what are the functions, how are we going to determine what's going on with this behavior. Then we're going to uh, come up with a hypothesis or a reason behind the behavior. What do we think? Then we're going to test that hypothesis by either altering the antecedent, what happens immediately before that behavior, or how are we changing our consequences, or what happens immediately after that behavior. So a lot of times we get into thinking about consequences as punishment. What did we do to that student? But consequences, if you think about it, are the things that you do or the other folks around that student does in response to that behavior. It's immediately afterwards. So little Dougie turns the chair over in class, all the kids laugh at him. And so the consequence of turning that chair over was the kids laughed at him. He got attention. So just be aware that your consequences aren't necessarily punishment or discipline, but it's how you respond to a behavior. Then after you test your hypothesis, then you develop your behavior intervention plan. And again, like I was saying, the behavior intervention plan has a section. Mr. May mentioned teaching replacement behaviors. You have to teach that desired behavior, then we have to develop a replacement behavior, teach that replacement behavior. Now, replacement behaviors are temporary. They're not going to last a long amount of time because they are small steps or they're things that we can live with that student can use instead of that inappropriate behavior. It may not necessarily be the exact desired behavior we want to see, but it is an improvement. It is something we can live with short term until they develop that skill that they're lacking to be able to exhibit that desired behavior. So, and make sure or try to ensure that your behavior plans are, like you said, reviewed, uh, you know, uh, several times, to see if there is a change in the behavior. If the behavior improves or the desired behavior is shown more often, then continue with the plan as it is. If the desired behavior isn't being shown or the inappropriate or undesired behavior is increasing, then you need to look at your behavior plan. Whatever we're doing is not working. So, and with the behavior plan, also, you're looking at setting events, you're looking at the antecedent, the behaviors, you're looking at consequences, what are the desired behaviors, what are the replacement behaviors, how are we going to meet those needs that student has. And again, like I said, you have to teach that behavior that you want to see. So, thank you. Oh, and we do have the task group across the state developed uh, yeah, I guess you could say new or a new version of the FBA forms and the behavior intervention forms that are more streamlined, kind of easier to just navigate. And so, if interested in those, we can get those out to your directors, and then they could send those on. Just contact. Well, we'll try to get those out to someone. So just let us know if interested or they can be found on kybehavior.com, which is a website that the task groups are responsible for. kybehavior.com.
So let's move on here. Now, this is another concept and something that sometimes is misconstrued, but there is the application of a 45 school day interim alternative educational setting when certain conditions warrant this special attention. What are they? What do you know about the 45 school day interim alternative educational setting? Weapons, drugs, serious bodily injuries, I think is the way the regulation is written. Now, what we're saying here is if you have a student that has one of these infractions where they bring a weapon to school, or they've got found with drugs on their person, or they've harmed someone, they've physically injured someone, uh, they can be subject to a 45-day removal without a manifestation determination. However, I think we've talked to Teresa Combs about this in the past, and she says go ahead and do the manifestation anyway and look at the plans and the evaluation, the information that you have, and look at what you were doing with that student, and make sure that when they do return that you've got a plan in place that meets that student's needs. Now, it's a high bar for serious bodily injury. Okay, there have been court cases across the land that would blow the everyday passerby completely off the map in terms of how the court saw serious bodily injury. We've seen teachers really take some injury and then only to have a judge rule that they could not impose the 45-day removal. And so I just want you to know that. I want you to know that is a possibility, and that's something, if you have that going on, that even when a student has a disability or a 504 plan, this can be applied, a 45-day removal without questions asked. But Teresa Combs says go ahead and do your due diligence in regards to making sure that we've got evaluation information, making sure that we have been implementing and that we have been teaching and applying the IEP in the correct sort of way. I think this has been the answer of the day, and we don't have to place it in the chat, but you can if you want. We have a removal for drugs, a removal for weapons or serious bodily injury, and they want a removal without an FBA and without a manifestation determination. What should we still provide? And that's the question. So put your thinking caps on one more time here, and let's talk about that for a real minute or two. We have to provide FAPE. That's exactly right. And I think that goes without saying. You just, once a student has the protection under IDEA, there's no time when we can just say this or that. Now, there has been some legislative help in Kentucky for superintendents, and there are times when a student can be expelled and placed in an alternative situation, but we still have to provide FAPE. That's a given. And so, if you're thinking about expelling someone, check with us. Let us make sure that we're doing things the right way. Make sure that we're reviewing our plans. Make sure that we've been implementing our plans. Make sure that we have data. The seminal court case, the landmark decision. I've told you guys this before. You know what's coming. Andrew was able to get, and he was a behavior case. He was able to get all the way to the Supreme Court because the district did not have progress monitoring, because the district had failed to include the parents in the decision making, and because goals were copied and pasted year to year, and because they were essentially doing nothing with the student except giving him a place to come and hang out, a babysitting service. They could not prove that they had taught the kid anything, and it got to the Supreme Court. So just keep in mind, the theme of the day is when they have an IEP, when they have a disability, we have to continue to provide. And we have to figure out a way to write it in such a way that when we remove them or restrict their environment, that we've done it in a way that is meant to bring progress. It's written in that way. It's done in that way with fidelity. So don't want to give you any kind of misconception when it comes to that. Principals should provide training to ensure staff as well as and that to ensure staff are well versed in PBIS. Now, I talked a little bit about transformational leadership, and Doug talked about making sure that plans are done with fidelity. And he talked about one of the things that was really hard is taking data. Now, when I talk about transformational leadership, you might chuckle at me a little bit. I know you have lots of things on your plate, but these proactive strategies, what would be wrong if you're really all about that unified voice and strong culture and putting change in your pocket with your teachers and helping teachers and modeling for teachers? What would be wrong with you figuring out how to take data and going in and modeling that, in certain situations? Those are the types of proactive strategies that we at KVEC think are going to make a difference. Now, we also know that, while we're making progress in the KVEC region in terms of students with disabilities outcomes, we still got a long way to go. And so we think at KVEC that one of the ways to do that is through strong leadership, and that the leaders know about things like Andrew, the leaders know about things like Terry Scott and PBIS, and they also then take the bull by the horns, whether they have a strong background or whether they have the capacity to provide, but they have a firm belief rooted in transformational leadership, and that's going to make a difference. Linking what we know about substantive pieces of the IEP and whether or not we're doing progress monitoring with fidelity, whether it be behavior or reading, we need to make sure that we're providing the best for our staff and that we have the ability to go in and model specially designed instruction, model PBIS, take data, show teachers that we have those skills in our toolbox as well. And that's going to make the difference. That's going to link our instruction to those goals. It's going to link our Kentucky summative assessment to those goals. If we make better readers, the test score is going to take care of itself. Firm believer in that. And I don't mean to get on a soapbox, but that is something we're pushing every day here from Kentucky Valley Educational Cooperative. It's something we believe in as a staff, and certainly we're here to assist you and help you. But a lot of what goes on in that school hinges on the leadership you provide and how active you are in being a role model that can actually get the job done in the classroom. The law is very clear that as an ARC chairperson, as the principal, as the administrator, as the instructional leader in your school, that's lots of hats to wear, but the law is very clear. You're supposed to know what specially designed instruction is. You're supposed to be able to provide it and supervise it. And that's the law. And so part of that would be taking data in that classroom where that student, because that's the number one thing you get back from a general ed teacher in RTI. That's the number one thing you get back from a special education teacher. I've got 7 or 8 kids in here I'm responsible for. I've got 25 kids I'm responsible for. When am I supposed to take data? Well, we have to teach them how to take data. And because the data drives our decision making, and the data is going to make big things happen, those little details, those little intricate details, that is hard work, is the only thing that moves the needle. And we have to roll up our sleeves. We see evidence of it here at KVEC. We see evidence with folks like Chastity Craft and Stephanie Kidd going out into the schools and providing the know-how. But it really just comes down to, we don't have any magic bullets. It's just roll your sleeves up, get repetition, get response from students, get engagement, and give feedback, and do it all again tomorrow, and do it all again tomorrow. I had a conversation not too long ago about attendance, and what we've been finding out is that attendance is not only bad amongst our students, it's bad amongst our school staff. And so we have to be all in. We have to care about our kids, and we have to make sure that we're providing these proactive strategies. And once we get that kind of thing rolling, we see that culture change, then students begin to want to come there. Okay. And so that's, and you are the voice. You're the person that can make it happen as a principal. Communication and collaborative decision making. Ensure open communication for fair, lawful, and impacting disciplinary actions. Teresa Combs would say, do not put anything in a plan that's not intended to bring progress. So I think that's very, very, very key. And then the other thing that we would note is that ongoing professional development. We're here for you. Special education is complex. I know you would agree. Do you have comments about that? How complex is it? Invest in your staff. This element of transformational leadership, compliance brings the same old results, but substance and implementation and knowing how to teach and knowing how to take data and knowing how to give feedback and knowing what works is important. Compliance is one thing, and compliance is important. We're not saying compliance is not important, because if you fail to implement, if you fail to procedurally do child find activities, if you fail to procedurally provide IEP monitoring, if you do not have the timelines taken care of, you don't have the right people at the table, you don't sit in the meetings, and you're not the professional in the room, compliance is an issue. It will bite you every time. But we're talking about moving beyond compliance, moving beyond the same old, and making sure that we've got to put our best foot forward in public education if we're going to perpetuate ourselves.